Yes, issue 2.
My lords, my lady, just to say I'm joined by my learned junior, Mr. Wilmot Smith.
Very pleased to see him.
So yes, issue 2. This is where we say, even if we're wrong on issue 1, exclusivity, the main claim, period, unjust enrichment claim, is in any event bound to fail. What I'll do is set out my position why we say that, and then respond to my learned friend's new skeleton argument on that issue. First thing I want to do, just to outline important principles in unjust enrichment, is to go back to ITC Volume 5, tab 52, page 1369. Picking it up at paragraph 38, which is page 1388. This is the Supreme Court explaining, giving a little tutorial, as it were, on unjust enrichment. And I'm just going to pick out some points. Paragraph 38. It would be unwise to attempt in this appeal to arrive at a definitive statement of the circumstances in which the enrichment of a defendant can be said to be the expense of the claimant. Nevertheless, in view of the uncertainty which has resulted from the use of vague and generalised language, this court has a responsibility to establish more precise criteria. Some observations of a general nature should therefore be made before turning to the specific context in which the issue arises in the present case. It should be said at the outset, these observations are concerned only with personal claims and not with proprietary claims. First, it's important when dealing with personal claims based on unjust enrichment to bear in mind what was said by Lord Gough when rejecting the submission that when dealing with a claim to restitution based on unjust enrichment, it was for the court to consider the question of injustice or unfairness on broad grounds, and that it should deny recovery if it thought that it would be unjust or unfair. Dropping down to, after the indented text, Lord Stein remarked in Bank Financière, unjust enrichment ranks next to contract and tort as part of the law of obligations. A claim based on unjust enrichment does not create a judicial license to meet the perceived requirements of fairness on a case-by-case basis. Legal rights arising from unjust enrichment should be determined by rules of law which are ascertainable and consistently applied. So, picking it up again at paragraph 42, the structured approach provided by the 4 questions does not therefore dispense with the necessity for a I'm pausing because although the 4 questions are in our skeleton, I'm not sure that I took you to the paragraph setting them out. It really was their enrichment at the claimant's expense for an unjust factor, for example, mistake, and then the question of defence.
Paragraph 24.
I'm grateful, my lord.
Lord Reed.
So carrying on, I'm grateful. Paragraph 42. The structured approach provided by the 4 questions does not therefore dispense with the necessity of a careful legal analysis of individual cases. Carrying out that analysis, it's important to have at the forefront of one's mind the purpose of the law of unjust enrichment. As was recognised in the Menelaw case, paragraph 23, it's designed to correct normatively defective transfers of value, usually by restoring the parties to their pre-transfer positions. It reflects an Aristotelian conception of justice as the restoration of a balance or equilibrium which has been disrupted. That is why restitution is usually the appropriate remedy.
I'm not sure I understand what normatively defective means.
There's a transfer of value.
I understand what that means.
I
understand what
it's a real reference to the unjust factor, as I understand.
I understand what defective means. What's the impact of the word normatively? It means according to legal concepts, does it? Legal norms.
According to, well, I suppose, the unjust factors. It ought not to have happened, but it did because of mistake or duress or...
Yes. Okay.
I'm getting a nod from my junior. Okay, so nature of the various legal requirements indicated by the at the expense of question follows from that principle of corrective justice. They're designed to ensure that there's been transfer of value, the kind which may have been normatively defective, that is to say, defective in a way which is recognised by the law of unjust enrichment.
Well, there's the answer. Thank you.
Failure of basis on which the benefit was conferred. Failure of basis being another example as a mistake of lawyers. Therefore, I hope my answer wasn't too far off. The expression transfer of values, however, also too general to serve as a legal test. More precisely, it means in the first place the defendant has received the benefit from the claimant, but that is not in itself enough. The reversal of unjust enrichment, usually by a restitutionary remedy, is premised on the claimant's also having suffered a loss through his provision of the benefit. And then moving to 52. As explained earlier, the at the expense of requirement is not satisfied merely by the direct receipt of a benefit. Dropping to the end of that paragraph, a but-for causal connection between the claimants being worse off and the defendants being better off is not therefore sufficient in itself to constitute the transfer of value. And I'll make this point later, but one way we say this works in our cases, yes, HMRC obviously is better off when a claim is not made in time against it for BDR relief, but that's not the test. At the expense of requires something different, that there is defective transfer of value. And if we go to paragraph 59, nor is the at the expense of requirement satisfied by a connection between the parties' respective benefit and loss merely as a matter of economic and commercial reality. Then dropping down to 60, a more fundamental difficulty with an approach based on economic reality arises from the fact that the purpose of restitution is not to compensate for loss but to reverse the defective transfer. Looking to see who has suffered an economic loss is not therefore in principle the correct way of identifying the appropriate claimant. Indeed, even in tort law, which is concerned with compensation for loss, the court is not concerned with whether the economic burden of the tort may ultimately have fallen as a matter of economic reality. I think those are the only points I wanted to go to by way of broad introduction. And then, if the court wouldn't mind picking up our skeleton, I'm going to turn to the example we give at paragraph 36, what may be called T1, T2, T3, and so on. So at T1, taking just by way of example the date 1980.
Sorry, can you just give us the paragraph again?
Paragraph 36.
I'm sorry, thank you.
Sorry, I should have said it's in core bundle tab 18, 201. I do apologise. So if I just go through the example, at T1, example 1980, BT accounts to HMRC for output tax on supplies A to O of £100. Of that £100, 10 relates to supplies A to B. And I just pause there and recall paragraph 5 of ITC, that VAT is due to HMRC at that point, irrespective of whether it's even charged to a customer or paid by the customer. The obligation, reference paragraph 5 ITC, is on the supplier to account for VAT. So the key point that follows from that paragraph 5, which is page 1380, I should have said, of the authorities bundle, is that BT at T1 had an obligation as supplier, and irrespective of whether it charged its customer VAT or was paid VAT by its customer to account to HMRC for VAT. And I'll come back to dealing with that when I deal with my learned friend's new skeleton. So then now move to T2, an example dated February 1981. At this stage, let's assume BT considers that in relation to supplies A to B, its customers were not going to pay and there was a bad debt, such that the £10 of the VAT accounted for at T1 should be refunded under Article 11C1 rights. From this point on BT's analysis, it has some claim to relief. It has some right to get the £10 back that it, as my learned friend puts in his skeleton, I don't agree with this, I say the obligation is absolute. My learned friend says it's a sort of prepayment, it's a...
provisional.
Provisional, that's right, I'm grateful. Yes, it's provisional because...
it's on account of your ultimate liability, but your ultimate liability turns out to be less if the tax base is less. That's the way he puts it.
Yes, and I'll respond to that, but it's just as a reminder of this is how he puts his case. So he says, if that's his case, his position is that when that bad debt arises at T2, when the £10 becomes a bad debt, as it were, at T2, then he has a right to get the £10 that he initially accounted for back.
Do you dispute that?
That he has the right to get back the...
Once the debt becomes a bad debt, then he does have a right to get it back, doesn't he, under Article 11C1?
My Lord will know the answer if he makes an on-scheme claim in time.
Yes.
But not otherwise. But the important point here is that my learned friend's case doesn't depend on that original £10 payment. I will explain, but if I just sort of go through the periods of time first.
Yes.
So my learned friend says he has a claim in restitution or something for the £10 paid at T1. At T3, BT accounts to HMRC for output tax on new supplies which I call P to Z of 150, and doesn't set off the £10 paid at T1. So it doesn't set off under the old scheme or at all. Now again, paragraph 5 of ITC applies. The £150 relating to the supplies P to Z was all due. We know all this from BTCA. It was all due, subject to an optional claim to relief. You don't exercise the optional claim to relief. You haven't overpaid tax at T3.
Whereas if the effect of the EU law was, as I think Mr. Cordara says, that somehow automatically your VAT liability overall is reduced, then you would have overpaid T3.
Yes, and to make that argument, the automatic and so on, I don't know if the court will recall, but I went through quite carefully the Upper Tribunal of 2023 because remember the magic of the automatic and of the dialogue and all this. That's the Iveco case. It's been...
You say, whatever might be the case of Iveco and Regulation 38, under bad debt relief, there's no automatic. As a matter of EU law, there's no automatic set off because Article 11C1 allows member states to set the conditions. One of the conditions set is you have to make a claim, and that is not said to be in breach of EU law.
Absolutely, and what mustn't be forgotten is the additional point I make. Iveco, Court of Appeal decides Iveco has a Section 80 claim. BTCA decides that BT doesn't have a Section 80 claim.
Yes.
And we know from...
And the Upper Tribunal has reinforced that, saying really no Section 80 claim, including under 1B.
So it's not open to me.
Even post Iveco, and indeed Lord Justice Nugee, who gave the judgment in Iveco, said that wasn't what I said. Yeah.
So absolutely accept what how my Lord described my position, but I add the further point.
Yes,
that,
I see.
it's not open to my learned friend to seek to argue Iveco here, and automatic magic, and whatever else he wants to say about Iveco. It's already been decided that IVECO does not apply to our case. And then continuing with my example, as it were, at T4, what I've designated T4 is 19th of March 1997 when the old scheme is repealed. We know from BTCA that BT had until March 1997 to make an old scheme claim for the refund of the £10 paid at T1. The shutting down of the scheme was EU law compliant. And at T5, BT makes its out-of-time claim under the old scheme for the £10 at T1. BTCA reject the claim and also its alternative Section 80 claim that it over-accounted or overpaid VAT. And we know from Upper Tribunal 2023 that that means at all under Section over-accounted for output tax or overpaid any sort of VAT at all. Paid VAT to HMRC that was not due to HMRC.
Can I ask,
Yes.
were there pleadings in the tribunal claims? There was a preliminary issue, 3 preliminary issues which went to BTCA, and then you struck out the rest of the claim. But were there ever pleadings?
Yes, because I remember working on asked it, what happens is they'll put in a grounds of appeal against HMRC's decision, and we put in what's called a statement of case, but it's really a defence to the appeal, and then discussion started between the parties about, given GMAC is in the upper tribunal, can we get there?
Yes. Can you catch
I'm afraid
up
they're
with
not
GMAC?
in the bundle though.
But I just wondered this, at T5 you say that what BT was doing was both claiming under the old scheme and making a Section 80 claim. Was that clear from their pleadings? Because I thought the letter before action, the 30th of March 2009 one, it wasn't very clear that they were making a Section 80 claim.
We've had this dispute, and the result is this. The upper tribunal said you were making an old scheme claim, you weren't making a Section 80 claim. The Court of Appeal agreed with the upper tribunal. The wording is something like, not even BT thought that it had a Section 80
Yes.
claim because around 126127 of BTCA. Now,
So, but they cross appeal
they did cross appeal.
to say, but we've got a Section 80 claim even if the old scheme has closed. Is that right?
That's right.
And
And
it's
we had
that
a-
which is rejected. Yes.
So I don't. So to answer the initial question, I don't recall if they pleaded Section 80, but it did emerge through the what we meant by our claim letter was Section 80, and
Yes.
then the cross appeal about whether it A, they had a Section 80 claim, and B, even if they had a Section 80 claim, did they bring the letter in time because it was the day before the Fleming window shut, and they lost on all that. So Section 80 is over. And that's why, I mean, perhaps I didn't flush out this detail, but that's why in the Upper Tribunal 2023, BT's point was twofold. One, IVECO shows that Section 80, subsection 1B has legs and so on and so on, but of course they also had to say, and nobody really made a finding of fact about the letter the claim letter that we made, so because otherwise, how could they keep their Section 80 claim alive? Even if they won on the IVECO point, it would be said, well,
You're out of
what does
time.
it matter? Yes. And the argument was made, there were preliminary issues, the court shouldn't have found findings of fact and so on. I'm summarising the position, but it's an argument they made for Supreme Court Commission. They didn't get it. It's an argument they made in the First Tier Tribunal 2020. Upper Tribunal 2023, no, definitively decided by BTCA, you didn't make a Section 80 claim.
So I had picked this up. BTCA rejects the cross appeal on 2 grounds. One, you didn't bring a claim in time, and secondly, in any event, you didn't have a Section 80 claim because it's not a case of overpaid
but the other way around.
Right.
Concentrated on we don't have a claim, but in any event, for the we agreed with the upper tribunal that
You
we
didn't,
didn't
bring,
make a section
you
80
didn't bring.
claim in time.
Thank you.
And that's why I think one of the first things I said yesterday was how wrong it was, how incorrect it is for my learned friend to suggest that it's common ground that BT has a Fleming claim. Far from common ground in every sense. No Section 80 claim because all tax paid was due, and also no Section 80 claim made in the Fleming window because the claim letter has been decided to be an old scheme claim, not a Section 80 claim. I'm not sure very much turns on it, but that's clear. And I think in the introduction to our skeleton, I outline and give paragraphs of what BTCA decided on that point. So the question under issue 2 is, can HMRC show that BT has no claim in unjust enrichment for mistake? In other words, that HMRC were enriched at BT's expense due to a mistake of law that BT made. And we have a series of points on that. The first one is, as I've said, BT doesn't seek restitution for the original £10 payment at T1. And the reason that BT doesn't seek restitution for the payment at T1 is because BT rightly recognises that the payment at T1 was not made by mistake. And so BT can't rely on Section 32, subsection 1, subsection C of the Limitation Act. It's stuck with the ordinary 6-year limitation period. It's no good, I mean, when my lord asked me earlier, what do you HMRC say about that T1 payment? Well, we say, if you don't bring the claim under the old scheme, then it's that's it about the T1 payment. But even taking my learned friend's position, he had some claim for restitution, presumably, for that T1 payment. 6-year limitation period, because at that stage there was no mistake. And that's why my learned friend needs to start saying, I made a mistake of law in failing to bring a claim, because mistake is critical to the extended limitation period.
So let me be sure I've understood this. If it were right that as a matter of EU law, the payment made at T1 is only a provisional payment and falls automatically to be reduced in the event of a Article 11C1 event, in this case the debt becoming bad, whenever that is, so that retrospectively you can see that there's been an overpayment, which is, I think, one of the ways in which Mr. Cordara seeks to characterise the case. You say that might, if it were otherwise right, which it's not, give rise to a claim for repayment of overpaid VAT, but it wouldn't be a mistake claim. So you don't get into Section 32(1)(c), so you've got 6 years, and or if it's a Section 80 claim, you're stuck with the limitation period in Section 80.
And IVECO, to make sure I get this right, IVECO's Section 80 claim and the automatic reduction and so on kicked in at T3. But my learned friend, and I'll deal with it, seeks to identify an unjust enrichment point at T3 or T4. That's certainly not trying to say that the T1 payment unjustly enriched HMRC, because I think my lord made the point to my learned friend yesterday. Perfectly fine that you pay, on making the supply, you pay HMRC at T1 your £10. There's no mistake there when you pay HMRC with £10. So
and that's not.
We move into T3 and T4 and so on.
Yeah.
Mistakes start being made.
And the requirement to pay on invoices, not in breach of EU law. Mr. Cordara accepted that right at the outset. Yeah.
not only not in breach, but what mistake did BT make at that point? It just did the right thing. There was no different provision at that point, position at that point under EU law either. So my learned friend needs the extended limitation period for unjust enrichment under 32(1)(c). That is, he has to show that there was a mistaken transfer of value. In other words, an enrichment of HMRC at BT's expense by mistake. And my learned friend tries to achieve that by saying, I failed to make a claim. That was due to a mistake of law. And HMRC were enriched by virtue of that. And as I say, I'm not always clear about how my learned friend puts his case, but if I could just take two ways I understand that he sometimes puts it. One way is, I had a restitutionary claim for the money, for the £10 at T1 after a bad debt arose. So I paid the money at T1 in anticipation of getting that money from my customer. When a bad debt arose and I didn't get that money from my customer, I have a restitutionary claim. Another way he puts it, and this is the more frequent way that he puts it, is to say, I didn't make a claim under the... Sorry, before I go to that point, I've just got to explain a little bit more about the restitutionary claim. So one way my learned friend puts it is, I've got a 6-year limited restitutionary claim. I didn't bring that claim in time, and now I have a mistake-based claim. You can do that with the restitutionary claim.
Where does the 6 years come from?
6 years is the ordinary limitation period for restitution.
Why?
Because it's Section 5 of the Limitation Act.
Yeah, it's treated as an action in simple contract?
Yes.
This is the fiction that restitution is a contract to repay what you're not entitled to?
That's my understanding.
There I think there's reference in at least one Supreme Court case to it being uncontroversial that it's Section 5, even though when you turn it up,
It says an action founded on simple contract shall have a period of 6 years, but it's what used to be called quasi. It's because
That's
restitution used to be quasi contract, and under quasi contract it was treated as if it was a fictional contract. Yes. Anyway, it's not in dispute. The Woolwich claim has a 6-year claim, a 6-year period.
Yes. Or however it's described, the only way that my learned friend's going to get home on limitation is if he shows it's a mistake-based claim and he pleads a mistake-based claim, because he needs 32(1)(c, which is the I didn't know until some point in the future, and that's when my 6 years starts running, when I had reasonable knowledge of the fact that I had a claim. So this aspect isn't dispute between us. My learned friend wants to say needs to say he's got a mistake-based claim in restitution. The way he does that is to say, because I say, well, we just had a claim in restitution, paid the money at T1, bad debt arose. You now say that you want the money back. That's a normal 6 year. Where's the mistake? My learned friend says the mistake is, well, if I had an ordinary, I'll call it ordinary for the 6 year limited restitutionary claim. I had an ordinary 6 year limitation restitution claim. I didn't bring it in time because I didn't know I had that claim, because I didn't understand EU law and the 11C1 rights. That's the mistake I made. Or more frequently, he says, yes, I had as the BTCA has told me, I had a claim under the old scheme, but I got to 1997 and I didn't bring that claim. And that's the mistake of letting time run out without bringing a claim under the old scheme. that grounds the unjust enrichment. And that's why most frequently the position is it's a mistaken failure to claim in time. That's how the purported unjust enrichment is framed. I think my learned friend accepted that is the primary way he puts his position yesterday in answer to questions from the court. Mistaken failure to bring the claim in time. Mistaken because didn't realise that the old scheme was
I think
not...
the way you put it was he believed that the UK had correctly implemented the directive.
I don't mind how it's put. Believed that it was correct implementation, believed didn't have an old scheme claim. However it's put, some mistake was made because after all, BTCA has said you couldn't make a claim under the old scheme, but I'm out of time. My focus is on the fact that you don't bring a claim you say you have by the end of the limitation period under the old scheme, 1997, does not constitute enrichment at BT's expense for HMRC. Yes, of course, HMRC benefits by not having had a claim for 65 million brought against it before the shutters came down on the old scheme. But we saw in ITC the fact that HMRC benefits or is economically better off isn't the test. It has to be a transfer of value, an enrichment at the claimant's expense.
There is a transfer of value. There's the £10 included in the 150, which is paid at T3. As I understand it, what may be said as part of the case is once I got a bad debt at T2, I had a right, I didn't know it, to assert that at T3, so I only needed to pay £140. And actually I paid £150. There's your transfer of value. And it's unjust because if I hadn't made the mistake, I would have realised and I would have filled in the box on the form.
But HMRC aren't enriched at T3 because we know that there was no limitation period under the old scheme. The claim could have been brought right up to 1997. So it's at T4 when the shutters come down that HMRC can be said to be better off because it's free of the potential claim. And at that point, there isn't some transfer, some payment to HMRC.
Sorry, you're saying there's no transfer of value at T4?
No, it's all that's happened is somebody's missed a limitation period. Where's the transfer of value? If I can explain using an example that's simpler than our case. A pays £10 to B and has, let's say, 6 years to claim it back. By mistake, A fails to claim it back within the 6 years and so is out of time. Yes, that mistake means that B is now richer than if A had indeed brought the claim in time. But there's no fresh enrichment at the time when the limitation point hits. A has a right to claim the £10 from B. It doesn't bring that claim in time. There's no fresh transfer of value from A to B. Were it otherwise, every time A has a claim against B for £10 and doesn't bring it in time, A would be able to say, aha, I made a mistake. I thought I'd issued the claim and I, in fact, hadn't.
So, I mean, in that case, there may be unjust enrichment at day one, but it's not a mistake. I think you're saying it's not a mistake-based claim.
Yes, there might be...
because
Sorry.
Yeah, no, you carry on.
No. I thought.
Because mistake isn't part of the cause of action, if you like. It's not founded on the consequences of the mistake. Is that a fair way of putting it? Or the enrichment doesn't relate to the mistake?
For 32(1)(c) extended limitation period to apply, mistake has to be an ingredient in the cause of action.
Yeah.
Sure, when A pays £10 to B, it'll have 6 years to try and get it back.
Yes, what I'm saying
no
is,
mistake.
on those particular facts, there may be unjust enrichment, but there's just not the necessary or right kind of mistake.
Yes,
in your example.
The mistake my learned friend is trying to find is to say, well, I mistakenly didn't bring a claim in time, and that left HMRC better off by 65 million. But there's no transfer of value at the time when you, or because you failed to make a claim. If HMRC owes you the 65 million, it owes it to you because you paid £10, there was a bad debt, and so on. It doesn't owe it to you because of some fresh enrichment, and at some later point you make a mistake. And as I say, that has to be absolutely right, because how could the opposite be the truth? How could the opposite be true? How could somebody, by failing to bring a claim in time, for whatever reason, mistake of law, mistake of fact, and it must be quite common for people to miss limitation periods because they made a mistake of fact or a mistake of law. I didn't know I had a claim. I knew I had a claim, but I didn't issue in time. How could it be that the failure to bring a claim in time itself constitutes enrichment at the claimant's expense, such as to generate some fresh cause of action, now founded on mistake and with the extended 32(1)(c) limitation period? It would make a nonsense of limitation periods. How would...
Is the answer that the mistake was the error of law as to the right to set off at T3 the £10 that had turned out to be a bad debt, and the failure to claim is part of the causative chain between that mistake and the unjust enrichment, or the right to claim restitution of the unjust enrichment which happened at T3?
Well, and this is why it's slightly difficult, because I can't be certain exactly how my his case. I'm trying to cover all the bases.
I'm just putting a proposition to you. Whether or not it's the case against you, I don't know.
Yes. So the reason it's the I didn't bring a claim in time at T4 that is important is because at T3 HMRC weren't enriched. All that happened is that there was a claim out there against them, an ability to set off, or to write a letter to HMRC and say, we've got a bad debt relief claim. And it could have been done at T3, it could have been done at T3+1, T3+2, T3+3. There's no magic about T3, in other words. What my learned friend needs is that finality. HMRC are now better off by 65 million because I've missed the statutory limitation period.
Put it another way, they're only better off at T4.
They're better off at T4, but there's no transfer of value at T4.
But they are better off at T3 than if BT had asserted its claim at T2, which it could have done. The £150 is cash that they've received. So that's a transfer of value. That's better than receiving £140. Had BT realised at T2 that it could have set off for £10, it would have only paid £140. Why is that not a transfer of value which is made by mistake? The mistake being a mistake of omission, and it's true that transfer, that mistake could still have been undone for another 18 years, up until 97, but it never was. And the mistake was in T2, not asserting it, or at T3 and not asserting a claim, which caused them to pay the full 150 instead of 140 as they could have done. Why is that not a mistake which leads to BT paying £150 instead of £140 and HMRC being actually £10 better off, albeit subject to the potential for it to be clawed back right up till T4, which it never was. But it never was clawed back, so they were £10 better off at T3. I think that's what is. I think that's what's being said against you.
There's, can I take it in stages, as it were? First, let's stick with my learned friend's position that the mistaken failure to claim in time constituted an unjust enrichment. That's a T4 point. And we say, to that point, that would make a nonsense of limitation periods and so on.
Yes, I have that. Yeah.
My learned friend says, and this is closer to his pleaded case, at T3, I overpaid VAT.
Yes.
Because I didn't make an old scheme claim.
And that was also a mistake. I could have done it at T3 or at any time between T3 and T4. I didn't do it at any of those times.
And what do you say, not your lordship, but what do you BT say happened at T3? I overpaid tax, is the answer. When I didn't make an old scheme claim, I overpaid tax. I paid 150 instead of 140. To which the answer is, BTCA has already said that at no point, T1, T3, T4, did you over-account for output tax or overpay output tax or VAT at all in any aspect of Section 80 confirmed by the Upper Tribunal 2023. In other words, you didn't pay tax not legally due to HMRC.
Well, I suppose it begs the question as to whether that's the relevant test. You say that, I think you're saying because it was legally due, that can't be any form of enrichment. Is that what you're saying?
Yes, because there's a defence is how it's normally seen, but it can also be just seen differently as a sort of denial of the other factors. There's a defence if the payee, it's in our skeleton, just so you have it written down. The payee cannot be said to have been unjustly enriched if he was entitled to receive a sum paid to him. And we give lots of references.
Sorry, where are you?
So paragraph 42 of our skeleton.
Thank you.
The reason we give lots of references is because we want to show that it's a heavily
I
entrenched
see what you
principle of unjust enrichment. If you had a legal obligation to pay, and you didn't pay to HMRC anything not due to HMRC, which has been found in BTCA, then your T3 argument also fails.
But then at some stage you have to deal with Deutsche Morgan, which says the ACT was due, legally due, because you didn't elect. But the whole reason you didn't elect is because you were mistaken. And if you hadn't made that mistake, you would have elected, and if you hadn't elected, you wouldn't have paid, and that's enough. Why can't you say it's exactly the same here? If you weren't mistaken, you would have asserted the bad debt set-off. And if you had asserted the bad debt set-off, you wouldn't have paid 150, you would have only paid 140, and that's enough. What's the difference?
The short answer to that is, and it's the points picked out in our skeleton, that in Deutsche Morgan Grenfell, HMRC conceded that there was a claim in restitution. The argument was over whether there was a mistake. And the second point, and the references are in our skeleton, is that rightly or wrongly, and there's academic and Supreme Court debate, and we can let them worry about it, rightly or wrongly. In DMG, it was considered that there had been an unlawful exaction of tax when it's being early. In other words, the fact that advanced corporation tax had to be paid, the same tax that would be paid eventually but was paid early, was an unlawful exaction of tax contrary to EU law.
Yeah.
Not our case, because here we know from BTCA, no tax was exacted from BT that was not due to HMRC.
Okay, thank you.
So my learned friend can have interesting debates about whether in DMG the tax was technically due or truly due, which of their lordships was right. I don't need, my learned friend seems to say I should enter into the battle with the commentary as to whether DMG still stands or what precisely it means and so on. I don't need to. Because in our case, and even my learned friend doesn't say this in his skeleton, in our case, BTCA didn't say, you have no Section 80 claim because the tax was technically due to HMRC. It says you have no Section 80 claim because tax paid was the tax due, subject to an old scheme claim for relief that you didn't bring. So it's a bit of a, in my submission, red herring DMG, because it can make for interesting debate. But when faced with a Court of Appeal decision saying you have no Section 80 claim, i.e. no tax you paid to HMRC at T1, at T3, at T4 at any point was not due to HMRC. You don't have a San Giorgio claim, in other words, you don't have some unlawful levying or charging of VAT of tax. Any way that BT puts its case is a Section 80 claim that's been rejected because no tax paid that was not due to HMRC. And that's why I say this issue 2 can be, the claim can be struck out even if I'm wrong on exclusivity. When you have this position from BTCA that the restitutionary version of, the statutory version of restitution, Section 80, has no application because all tax paid was legally due, you're not going to get home on common law restitution either. You can point to as many mistakes or formulate them in any way you like, but ultimately it comes down to was the tax that was paid to HMRC legally due to HMRC. Yes.
So you say that's a fundamental element of a restitutionary claim, that you've got to point to some tax that was unlawfully exacted.
Or paid that wasn't due. It takes various formulations, yes, but ultimately that. Because if it was due, then that's a defence to an unjust enrichment claim.
Is Section 80 designed to implement in UK law the San Giorgio principle?
Absolutely. That's why when I've been giving examples, I've been saying, and of course you see they were bringing a Section 80 claim relying on EU law rights, because that's what happens. It's supposed to be, I think it's actually said in Leeds City Council, but it's supposed to be a comprehensive, and it's certainly in our skeleton argument, it's intended to be a statutory answer to restitution. And that's why you have Section 80 subsection 7 ouster, and you've had it since the dawn of the Section 80 system under Section 24 Finance Act 1989. Any arguments that tax paid was not due shall be made only under Section 24, now Section 80. It's supposed to be a comprehensive statutory restitutionary regime. Paragraph 11 of Leeds City.
And has it been
Sorry,
held?
paragraph 11 of our skeleton argument.
Has it
describing
been
as such.
held to be compliant with EU law? I mean,
Section 80.
Section 80. I mean, it
Well,
imposes limitation periods, and it.
Section, if my lord is thinking of the sort of Fleming debacle and the changing of limitation periods with
Yes.
a transitional period and so on, that happened in 1997. A 6-year limitation period was shortened to 3, therefore retrospectively without a transitional period. And that's why in 2000, I want to say 2009, the Fleming window opened and said, if your claim
Closed in 2009.
well, it opened and closed in
I think it was
2008.
open for about a year.
They had a year. So 2008 it opened. 1st of April 2009 it closed to allow those who had claims pre 1996 to bring them in the Fleming window. So yes, there was a problem with that limitation period retrospectively changing. That's been fixed. My learned friend said, I got a Fleming letter in time, the day before the Fleming
Yes.
window closed. BTCA said, A, your claim is not one for restitution because tax paid was the tax due. C, the adoption of Mr. Lesoc's arguments at paragraph 30 and then paragraph 125 to 128 of BTCA. Same position in GMAC Court of Appeal, around 133 to 134. And he also didn't have a Section 80 claim letter anyway.
Yes.
Now, it's been very helpful to have the discussion on DMG, but can I just finish up on the point I was making just before we went to DMG, when I was making the point about T4 and the failure to bring a claim doesn't constitute an unjust enrichment. In my submission, it's an obvious point, otherwise there'd be no limitation periods, it wouldn't function properly. And so I haven't been able to find a case that says it, but I rely on prudential by analogy, if I may. Prudential and the Supreme Court. So it's volume 6, tab 56, page 1481. This is the case that overturned the decision in Sempre Metals, which held that compound interest was available in unjust enrichment cases. And it's the reasoning that, in relation to that point, that I rely on. I invite the court to read from 69 to the end of 74. And the point we make is that the key reason why there was no unjust enrichment, there was not an unjust enrichment claim for interest, was that the only defective transfer of value was the 1,000 which became due on the 1st of April. The defendant then has the benefit of the £1,000 for any period when the defendant does not pay to the claimant. And we say, and this is the analogy, where the claimant does not claim that £1,000 from the defendant, that doesn't constitute a fresh enrichment at all, or ground any further claim in unjust enrichment. There's only been one defective transfer, the first £1,000. How does my learned friend in his latest skeleton deal with the problem that I raised regarding my T1, T2 examples and the section 80 DNG answer? How does my learned friend deal with that? He says, mine is a case of mistaken forbearance. We say that's not his pleaded case, but can I try to answer the mistaken forbearance case in any event? Mistaken forbearance and the Gibb case. Volume 3, tab 38, page 789. If I could summarise the position, Miss Gibb had her employment by an NHS trust terminated under a settlement agreement on the basis that she would be paid £75,000 in lieu of notice, and then also receive compensation for another £175,000. In return, under that settlement agreement, Miss Gibb accepted the termination of her contract and gave up any contractual or statutory claims. That's the forbearance. Miss Gibb agreed that she would not bring claims in exchange for the money under the settlement agreement. And what happened was, in the end, Miss Gibb was paid the £75,000 in lieu of notice, but not the £175,000. That wasn't paid by the NHS Trust because it argued that the £175,000 was so irrationally over-generous that it was ultra vires its powers. And the Court of Appeal held that that was wrong. The settlement was not irrationally generous, and Miss Gibb could have her £175,000. That was the decision. For your note, paragraph 22 to 23 at page 799. But it's the obiter that my learned friend relies on. Sorry, I'll just find the page. Yeah, the Court of Appeal considered then a further argument made by Miss Gibb in the event that the court agreed with the NHS Trust that the payment would have been ultra vires. Miss Gibb's argument was, if the settlement agreement is ultra vires, I would have made a claim in unjust enrichment. Sorry, I have a claim in unjust enrichment because under the settlement agreement, I gave up my statutory redress on the basis of the ultra vires and void settlement, and I've thereby enriched the trust. And if I could invite the court to read paragraph 30. Sorry. Here I've given the court the wrong page number.
No, I think it's page 802, 30. Which page?
802.
802.
Bundle.
Sorry, yes, I
There is
gave
no
the court
other
the wrong
page.
reference earlier. It's page 802. I'm very grateful to my learned friend. The judge below had held that there had been no enrichment of the trust on the basis that Miss Gibb, in fact, had known of the trust's position before the statutory limitation period ran out. The Court of Appeal disagreed. It said it wasn't, the question wasn't whether Miss Gibb could have avoided the enrichment, it's simply whether the defendant had been enriched at her expense. And then paragraphs 32 and 34. I can invite the court to read those. And we say that my learned friend can't rely on the Gibb case because what happened in that case is that Miss Gibb agreed to spare them the expense of the statutory payment, or the very likely statutory payment. But BT didn't agree on any description of events to spare HMRC some expense at all. It didn't forbear. Simply missed the limitation period.
So you don't say this decision is obiter decision is wrong. You say it's distinguishable.
Absolutely.
You would say effectively that Miss Gibb gave up something of.
Sorry, I apologise.
Miss Gibb gave up something of value when she signed on the dotted line. And you can see that she hasn't, after that she's got no rights.
Yes.
She's lost the rights by signing on the dotted line. You say BT never did that. It lost the rights, but that was at T4 as a result of a change in the law.
Didn't enter some agreement or with HMRC where it said keep the 65 million. Anything along those lines. It's not a Gibb case. And just in case I misspoke earlier, my lord, I didn't quite catch what was put to me. It was obiter, but I don't say it was.
You don't say it was wrong.
I just say it's distinguishable. It's not our case. Yes.
And so what she would have got in unjust enrichment is the value of the unfair dismissal compensation claim.
Something along those lines, yes.
Which was quantifiable and quantified, yes.
I think there is some discussion about quantum, but it would have been something along those lines. What she was actually giving up is a lost chance sort of situation, because she would have brought a statutory claim and I think there's some discussion of that in the case. But what's critical for our purposes is that there's no forbearance. BT is not a forbearance case. I'm not aware of other forbearance cases. Gibb is the one that's always put forward, but it's not analogous at all. Helpful questions, I think, have mean that I've covered quite a bit. The references, the DMG references, where I simply answer questions without reference, are in our skeleton when we deal with DMG in paragraph
44. I think.
Yes, it's 43 to 46, where we say D&G doesn't help BT, and that Mr. Justice Miles was wrong to think otherwise. With respect. And then, if I could, that's roughly the discussion that took place below and led to the judgment of Mr. Justice Miles. In last week's 39, I say that not to raise another criticism, but just to distinguish it from the previous skeleton. The 39-page skeleton, we have a whole series of responses to issue 2 and 3, and I will try and just take them in list form because there's quite a lot. If I may, and do obviously stop me as I go if there's something I can explain further. And I should say this at the outset, again with respect, that the sheer volume of points that are made in the new skeleton, the last week's skeleton, shouldn't give this court concern that this shouldn't be a strikeout, because look how complicated it is, because we say that the series of points are not good points that should deter this court from striking out the under issue 2.
Well, if they're bad points, they're bad points. Doesn't matter how many there are of them.
No, but there's a lot to get through, and it starts sounding more complicated than it in fact is, and that's what I'm going to try and do, sort of just show why a lot of it has straightforward answers, or has gone, or it's res judicata.
Does anything in issue 2 turn on the facts?
No. Scanning the 39 pages, no, not at all. The argument, and this is another point that I make.
It's an in-principle argument. It assumes that BT can establish its mistake and that it wasn't discoverable until recently and all that.
But I'm not taking the discoverability point other than on the 9-month claim.
Yeah.
I'm not taking it for, I mean, I've tried, as I say, to take points that are strikeout points. I haven't come across any of the arguments that depend on, well, the High Court will listen to all the evidence and then decide. And I think one point my learned friend might say is that strikeouts should not be given on developing areas of law.
Yes, that's a different point.
And that's made in relation to DMG because of the controversy around DMG, but that's why I say I've cut through that. DMG was under EU law an unlawful exaction of tax. Section 80 deals with domestic and EU law claims, and it's been decided against BT that it doesn't have, its circumstances are not that it paid tax not due, including when it failed to make a claim under the old scheme.
Yep.
That's why I said before, according to BTCA, it didn't overpay tax at T1, at T2, at T3, T4. And we would say game over. Now, one of the points, some of the points come up again later in the skeleton, so I may not be giving a comprehensive list of paragraphs, but it's around paragraph 13 to 14 of my learned friend's skeleton. The court may have seen reference to Article 11A, Elida Gibbs, law, and so on, for the proposition that BT had no liability to pay tax because in VAT law the taxpayer is a collecting agent for the state and they're liable only to account for VAT actually received. It's the idea that the trader is not supposed to bear the burden of the VAT. It charges VAT to its customer as collecting agent for HMRC and passes it on to HMRC. And my learned friend's point is BT is bearing VAT of 65 million, and that can't be right.
It should, if it all works perfectly, be borne by the ultimate consumer, the entire VAT burden.
Except in exempt supplies, because there's no input tax deduction, and therefore you get some tax burden on the trader, but not this case. So yes, the intention of the VAT system, with some exceptions, is that the trader doesn't generally bear the burden of the VAT. But we say that's not a consequence of Article 11A. It's only a consequence of Article 11C(1). And the reason I stress that is because I suspect that the reason my learned friend stresses Article 11A so much, the taxable amount is the amount obtained or to be obtained and so on. And the reason my learned friend went to Elida Gibbs in his opening remarks and so on, because my learned friend, after all, needs to get away from 11C(1). My learned friend can't say I overpaid tax according to Article 11C(1) because of BTCA. So he says, really the question is one of Article 11A. And I overpaid tax under 11A. Because it's 11A that deals with the true tax position. And I apologise if I'm mischaracterising, but I'm anticipating how the point will be put further to the skeleton. And we say that's clearly wrong because of what was decided in the Grattan case. And that's in the blue file. Tab 3. If I could just summarise the position. Grattan concerned a period before our period, under the second directive. So, my lord, do you have the case? Sorry.
I'll find it, don't worry.
It's tab 3 of the additional authorities that I...
Yes, no, I've got it.
Yeah. So the reason Grattan answers my learned friend's argument is because what you have in Grattan is the second directive. And we know under the second directive you have a version of 11A, but you don't have a version of 11C.
Yes.
And so if I could just read from paragraph 19. Did I say that it's a reduction, price reduction, I think, case? I apologise if I didn't. By its question, the referring tribunal asks, in essence, whether Article 8A, I add there, that's Article 11A equivalent in the second directive, must be interpreted as conferring on the taxable person the right to treat the basis of assessment, I explain, the taxable amount, of a supply of goods or as retrospectively reduced, where after the time of that supply of goods, an agent received a credit from the supplier which the agent elected to take either as a payment of money or as a credit against amounts owed to the supplier in respect of supplies of goods that have already taken place. Dropping to 25, no provision of the second directive provided for occurrence of the chargeable event to be set at a subsequent time or its deferral in another manner, nor did the directive provide for alteration of the tax debt that has arisen. Accordingly, as the Advocate General has observed at point 41 of the opinion, pursuant to Article 5 of the second directive, a taxable person's tax debt arose in an amount derived from the basis of assessment, basis which was to be determined at the time of delivery. Therefore, neither Article 8A nor any other article of the second directive could be interpreted as meaning that regularisation of the basis of assessment or of the output tax after delivery, which is often the chargeable event, which is when the chargeable event took place, has to be permitted. Then paragraph 35, it is in that context that European Union legislature adopted Article 11C(1) of the Sixth Directive, which requires member states to determine the conditions under which taxable amount will be reduced retrospectively. In principle, that provision requires member states to reduce the taxable amount whenever, after a transaction has been concluded, part or all of the consideration has not been received. And we see the Goldsmiths reference. 36, as follows from paragraphs 25 to 27 of the present judgment, there's no equivalent provision in the second directive. Furthermore, Furthermore, the fact that the Council of the European Union adopted Article 11C of the Sixth Directive in addition to Article 11A bears out the interpretation that Article 11C was not inherent in Article 11A of the Sixth Directive or its predecessor, Article 8 of the Second Directive. So 11C is all important. My learned friend can't avoid the problem that 11C1 causes him by pointing to 11A. And there's an error I should point to at paragraph 49 of my learned friend's skeleton. He says that there were Section 80 Fleming claims, including in relation to IVCO scenarios going back to 73, i.e. remember 73 to 78 is the second directive period. It's January 78, the sixth directive comes in. That's just not right. IVCO tried to go back to 1973. The IVCO case kicked off around 2011. IVCO tried to go back to 1973. The Grattan decision came out and IVCO withdrew its pre-1978 claim. For your Lordship's note, I'm sorry it's not in the bundle, but I can't see how it can be controversial. That's recorded in paragraph 2 of IVCO's first tier tribunal decision, that IVCO started off with the 1973 second directive period claim and then dropped it. And in fact, so did BT. BT's...
This was originally a £90 million claim going right back to 73.
I can't quite remember how the figures work, but certainly my learned friend tried to bring a claim from 1973. We said, on what basis are you bringing a claim from 1973 given 11C1
That's
started?
recorded in the FTT's decision on the preliminary issues.
Sorry, can...
I think it may be recorded, it's only the upper tribunal, but I think it may be recorded there.
But in one of the tribunal.
Yeah, it is recorded somewhere.
Well, in any case, in our common law claim, nobody's trying to go back to 1973, and it's not out of the generosity of their hearts that BT and IVCO have withdrawn their 1973 claim. It's because of Grattan, because 11C1 is all important. And 11C1 kicks in at 78, not before that. And again, this is going to sound repetitive, but BTCA didn't say the tax paid was the tax due, technically, or the tax paid was the tax due under 11C1, but not really due under 11A. It simply said, absolutely, the tax paid was the tax due. So these arguments don't really, in my respectful submission, go far in any event. Then we have a little throughout, but in particular focused at paragraph 15 to 18, reliance on IVCO. The automatic reduction in the taxable amount and so on. The court has my submissions on that. It's simply not open to my learned friend to reopen IVCO and say BT Court of Appeal on Section 80 saying that all tax paid was due is somehow wrong.
That's because the UT has decided that.
Well, the UT has decided that BTCA decided that.
Yes.
As in all aspects of Section 80. And I mean, I don't need to and don't have time to go to IVCO, but if my learned friend chooses to, the court will see that Lord Justice Nugee was well aware of BTCA and GMAC. And we know from the short reference in the refusal of permission to appeal. Bad debt relief is different. So we say that the reference to IVCO very much lacks a punchline. There's simply no basis that it can help my learned friend. And around paragraph 18, my learned friend says that there can be no dispute that BT paid too much VAT to HMRC because it did not receive all the VAT paid to HMRC from its customer. That's just wrong. Of course we dispute that BT paid too much VAT. Another way to say that is that BT overpaid VAT. No, it did not overpay VAT. Not only did we dispute it, but we were successful on that point in BTCA. So BT didn't pay too much VAT. It simply was out of time to make a claim for relief. HMRC is not holding any money not due to HMRC at all.
You're holding money which wouldn't be due to HMRC had claims been made as they could have been and would have been but from a mistake. That's your position.
And another point that my learned friend makes is that chargeability of the tax is pursuant to a derogation, Article 10(2), that it's done at the point of invoicing. A, so what? But B, the standard position is that tax becomes chargeable at the time of performance, not payment. So it's a doubly bad point, if I can put it that way, because it's not as though the standard position is that you account for that when you get it. And this is a derogation where you account for that on invoicing. Standard position is on performance that you would account, or by derogation on invoicing. Shall I go to 10.2? I don't think it really goes anywhere anyway, because my own friend says the UK is perfectly well committed to have the derogation.
Yes, but
Shall I show?
no, yes, but yeah, do show us. But I'm just thinking how that works in BT's case. You get your phone bill after you've used the phone, not beforehand. So does that mean when you place the phone call, that would by default be when BT should account? So it's in there. It's actually an indulgence to them to pay later. Is that right?
But that's how I understand it, and just in case
I think it's a mix because you pay your line rental in advance.
Oh, well, yes, you may well do.
Article 10.
But I think your point is that on any basis, it's not payment as the default.
It's volume 1, tab 21, page 91.
When the goods are delivered, all the services are performed.
My lord, I haven't turned it up yet, but I will if there are questions on it.
Although it does say if there are supplies of services which give rise to successive statements of account, those should be regarded as being completed at the time when the periods expire. So maybe at the end of each quarter.
It's not when the key point is it's not when you get paid by
It's
your
not
customer.
payment. It's not payment. Yeah.
Another point that the court will see in my learned friend's skeleton, and I apologise if I haven't understood this, but my learned friend makes regular reference to some automatic set-off under section 81, subsection 3 of VATA. For your reference, that's paragraphs 20 to 23 of my learned friend's skeleton. If we look at section 81, subsection 3, it's at tab 13, page 62. Volume 1, I should have said. Volume 1, tab 13, page 62. subject to subsection 1 above, in any case where an amount is due from the Commissioners to any person under any provision of this Act, and that person is liable to pay a sum by way of VAT, penalty, etc., the amount referred to in paragraph A, i.e. I add an amount due from HMRC to the trader under the Act, shall be set against the sum referred to in paragraph B, to extend to the set-off the obligations of the Commissioners and the person concerned shall be discharged. And it's not quite apparent to me what the point being made here. There isn't any reference to section 81, subsection 3 that I could see in my learned friend's pleaded case. The difficulty my learned friend has with all of this, of course, is that there is no amount due from HMRC to BT under the Act. There is no amount due under the old scheme provisions. There's no amount due under the new scheme provisions. There's no amount due under section 80. So I'm not sure where this automatic set-off under section 81.3 comes in.
Well, you're saying in the absence of a claim, at least, there's nothing due.
Yes.
If a claim had been made under the old scheme, the position might be different.
If the claim had been made under the old scheme, we wouldn't know.
Wouldn't
We
be.
would all been scared years of litigation. And it's more than that. It's that BTCA says that having not made a claim under the old scheme, that's the end. And then my learned friend, another point made in the skeleton is it's the UK's fault that it made a mistake. UK's fault being that it enacted the unlawful insolvency condition. I've responded to that by going to Leeds City Council. Member states do make mistakes in relation to either not implementing directives or misimplementing directives. But that doesn't found unjust enrichment claim any more than it did for section 80. I think one case, I'll hear how my learned friend puts his case, but one case my learned friend refers to, I think in that context, is a case called Emmett. And Emmett has been said in 2 or 3 cases, including Fantask, to be limited to its facts. So the general position is that set out in Leeds City Council and Fantask, which I took the court to earlier.
I don't think we've seen Fantask.
No, it's in the blue bundle, but the reason I didn't go to it is because it's already been referred to in paragraph 41 of Leeds City Council. It makes the Fantask point. And I'll dig out for the reply, but just to tell my learned friend now, there is a paragraph in Fantask which I will remember. My junior will tell me it's round 51, where they say Emmett is limited to its particular facts. Paragraph 51 of Fantask. The DMG points I've dealt with. Then another point my learned friend makes is what he refers to as the machinery point, relying on the Excel case. Excel was a decision on whether to grant permission to amend. HMRC tried to argue that they shouldn't be joined to the claim, amend to join HMRC. HMRC said that they shouldn't be joined to the claim because there was, under the machinery of section 59B of the Taxes Management Act, an obligation to make payment in accordance with self-assessments. And the court said that it was at least well arguable that that was wrong, that there's a debt on the basis of self-assessment that doesn't itself create or determine liability. Interesting, but not our case. We know that that here BTCA has said, made clear BT had a liability to pay the tax, and the tax it paid to HMRC was due to HMRC. Didn't say that was the case for technical reasons. It didn't say that that was the case as a matter of machinery, anything of the sort. Then my learned friend relies on GIB. I've dealt with that. Another point my learned friend makes is the Meta-Gesellschaft-Hirsch case. It's made in his skeleton under issue 2. I think my learned friend said something about it under issue 1, but can I just deal with it now because it's in his issue 2 skeleton. It was said there that the UK couldn't blame the claimants for not acting diligently. If I could show court the case, Meta-Gesellschaft is in authorities. I'm afraid I didn't mark for myself the volume number. Volume 8, tab 73, page 2121.
Did you say 73?
Yes, tab 73, page 2121. This is the case that led to DMG, the case that said the advanced corporation tax regime in the UK was unlawful. And Meta-Gesellschaft, sorry, the UK in that case sought to argue that Meta-Gesellschaft should have sought to make a group income election, had it refused, and then could have challenged the refusal in the courts. And if we look at paragraph 104, what the CJU says about that, the orders for reference make it clear that, page 12167, the orders for reference make it clear that an appeal against such a refusal by the tax authorities could have been brought before the Special General Commissioners and then, if necessary, before the High Court. According to the National Court, before judgment could be given in such an appeal, the subsidiaries would still have had to pay advanced corporation tax in respect of all the dividends which they had paid out. And furthermore, if the appeal had succeeded, they would not have obtained reimbursement of the advanced corporation tax, since no such right to reimbursement exists under English law. If the subsidiaries had chosen to pay advanced corporation tax in respect of dividends paid before the determination of their appeals, they would nevertheless have been assessed in advance to advanced corporation tax, would have had to pay interest on those sums, and would have laid themselves open to statutory penalties if they'd been judged to have acted negligently and without reasonable cause. So in those circumstances, if Meta-Gesellschaft had paid the advanced corporation tax and therefore not sought the time value, the interest, under EU law, even if its appeal had succeeded, it would not have obtained the reimbursement. And it's in that context that the CJU concludes at 106 that the exercise of EU law rights in that case would be rendered excessively difficult if the UK could rely on an argument that Meta-Gesellschaft ought to have applied for the relief, been denied it, and then challenged it. 106. The exercise of rights conferred on private persons by directly applicable provisions of community law would, however, be rendered impossible or excessively difficult if their claims for restitution or compensation based on EU law were rejected or reduced solely because the persons concerned had not applied for a tax advantage which national law denied them, with a view to challenging the refusal of the tax authorities by means of the legal remedies provided for that purpose, invoking the primacy and direct effect of community law. So, in other words, the position under Metal-Gesellschaft is that the taxpayers, being resident abroad, couldn't make a group income election, and even if they'd tried and challenged a refusal, still wouldn't have got what EU law required them to get. They wouldn't have had effective protection of their EU law rights. Not our case, because we know from BTCA that it's been decided against BT and underlined again by the GMAC Court of Appeal decision that BT could make a claim and challenge the insolvency condition. And that would have sufficiently protected its EU law rights, it just didn't do it in time. As I say, in a long skeleton, I've tried to cover the main points, but I am entitled, I believe, to reply as well when I hear how my learned points my learned friend seeks to emphasise. So the last point I think I need to cover before I sit down is equivalence. Equivalence makes an appearance in the new skeleton. And as I understand it, my learned friend, so remember the dual important principles of EU law, mustn't make directly effective rights ineffective by making it virtually impossible or excessively difficult to make a claim, and the other point is that there mustn't be a breach of the principle of equivalence. As I understand it, my learned friend is saying that there's a breach of equivalence in the repeal of the old scheme in 1997 without its being reopened, having its own, if you like, Fleming window in 2008 to 2009, while Section 80 claims and input tax claims were given this Fleming window.
Sorry, for input tax and
output tax claims. So Section 80 claims.
Yeah.
The Fleming window opened, and also for input tax following the Fleming case, because Fleming was an input tax case. And as I understand it, my learned friend says, well, that's a breach of the principle of equivalence, presumably because he'll say that somehow they're sufficiently similar. The short answer is they're not similar, of course, because under the reason we had the Fleming window was because of the retrospectively shortened limitation period without transitional provision. And
just to be clear for my benefit, the retrospectively shortened period was in what is now Section 80.
It was a version of Section 80 that came in 1997, which so before 1997 before the breach, if you like, you have Section 80 saying you have 6 years to bring a claim.
Yeah.
And in 1997, Parliament said you have 3 years to bring a claim.
So I did try to my friend. It's just that my own
I don't know.
What was the pre-cap process? The Section 80 limitation was the equivalent of 32(1)(c. It was reasonable knowledge. That's why when the window opened in 2008, people were allowed to go back to the beginning of the 80 rather than merely 6 years. I think.
So there was a version, and I don't dispute what my learned friend says, but I will double check. But it doesn't matter, because yes, there was a version of Section 80 that said you have 6 years to bring a claim, unless it's a mistake case, in which case it's reasonable. It's the date of knowledge from the date when you reasonably could have identified that there had been a mistake. The problem was that under both those types of limitation periods, Parliament woke up one day and said, now you have 3 years. So somebody was sitting there with thinking they had at least the 6 years to bring a claim, and then is told in year 3 or year 4, actually, or year 5, what's the point, that now it's 3 years. So that's why it's called a retrospective shortening of a limitation period. Under EU law, that's impermissible without a transitional period. When all that was established, the Fleming window was provided for by Parliament under Section 121 of the Finance Act 2008. And so I don't quite understand how there can be a complaint from equivalence or any sort of equality type complaint. Why did those who had Section 80 type claims or input tax claims get a Fleming window, and why did IBT, who only had an old scheme claim, not get a Fleming window? And that's why I've included in my blue file some cases on equivalence, but it struck me that there's a more fundamental objection to my learned friend's position. How is the breach of the principle of equivalence going to help? What he's trying to do under issue 2 is establish that he has some claim in unjust enrichment. And he either has that claim or he hasn't. HMRC has been unjustly enriched despite the TCA findings on Section 80, or it hasn't. How's arguing about whether my learned friend should have been given longer going to assist? But just in case I've got that wrong, if I could just deal in brief terms, and I'll come back to it further and reply if the position is kept up. The Compass case in the CJU considered a complaint because relating to the Fleming window. Basically, when the Fleming window opened, it was slightly different for output tax cases in comparison to input tax cases by a few months. And there was a complaint about that as being unfair as between the two categories. CJU said, well, they're not the same thing. A claim for input tax deduction is not the same as an output tax claim. And I say bad debt relief is not the same as a Section 80 or input tax claim either. And the other decision I've put in the bundle, which I'll go to in detail if I need to, depending on how my learned friend puts his case, is the DCM in the Supreme Court. The complaint in DCM was, again, you're not treating like cases alike, and this time it was very close. The comparators were two traders seeking input tax deduction. The difference was that what are called payment traders essentially helped themselves to input tax deduction. If I owed HMRC £100 output tax and I want to claim £20 of input tax, I simply claim it. I help myself to it, as it were, and write my cheque for £80 when I give in my VAT return. For payment traders, it's different because they're waiting. They make good their input tax claim by getting a payment from HMRC.
You called them payment trade. You meant repayment.
Repayment traders are in a different position because their input tax exceeds their output tax, and so they're in the position of waiting for a cheque from HMRC. And the criticism that went to the Supreme Court was, well, these two aren't treated in the same way. What should happen when I'm a repayment trader and I ask for input tax from HMRC, it should pay it to me. Just as a payment trader can help themselves, HMRC should pay it to me and then assess me. The Supreme Court said, no, they're not quite the same position. And I can go to the detailed paragraphs if I need to. But the point I'm trying to make is that even with two input tax traders, one can see that there are justifications for slightly different treatment. My learned friend hasn't set out why treating bad debt relief differently from output tax and input tax claims under Section 25, when it comes to the Fleming window, is going to be a breach of principle of equivalence, or how that's going to explain under issue 2 that there was some enrichment at BT's expense when it failed to bring a claim under the old scheme. Can I turn briefly to issue 3 if there are no questions on issue 2? Take this quite quickly. I'll turn it up if it would help the court, but it's paragraph 118 of BTCA, where the Court of Appeal essentially said, for the 9-month claim, it's either the old scheme, it's either swept up into the old scheme and then see what we say next, or all that BT ever had was a restitutionary claim with a 6-year limitation period. And we say that has to be right for the reasons I gave under issue 2, that you can leave aside the old scheme point because I'm not making that point on strikeout, but what's a trader's position in that 9-month claim period? It's accounted to HMRC for a supply at T1, bad debt has arisen at T2, it's going to have some restitutionary claim because, of course, the domestic regime must find a remedy for directly effective rights. It's going to have some domestic remedy. What's that going to be? It's going to be some form of claim in restitution. You paid at T1 thinking you'll get the money from your customer. At T2, the debt became bad, and you want to argue that that means that HMRC shouldn't really keep your money and has to give it back to you. I'm not saying they have such a claim, I'm just saying that it'll be that kind of claim. And it's the point I made before. Where's the mistake? The only mistake is 6 years passed after my restitutionary claim arose and I didn't bring a claim. And I go back to my refrain. Mistaken failure to make a claim in time doesn't ground a fresh cause of action.
You also rely on issue 2 in the payment being made lawfully, as in the payment was made legally due. You say there's no unjust enrichment in those circumstances. But if that's right, it would be a complete, if that were right, it would be a complete answer to a restitutionary claim, and then there wouldn't be a domestic remedy for the 9-month period.
Except that the legally, if HMRC said it's legally due, gets into slightly difficult territory, but if I can explain. If HMRC tried to say the sum you paid us is legally due, the trader would be able to say, no, it's not, because I've got directly effective rights under 11C1. The reason it's different for the main claim period is because the old scheme changes the position. Under the old scheme, it is due and stays due until there's some claim to relief under the old scheme. The 9-month claim is more like Iveco territory, as in there's no...
Okay.
My learned friend is looking at me because I don't say it's Iveco territory. My case is swept up into the old scheme and so on. But I'm just trying to orientate the debate. In the 9-month claim, there is no old scheme. So it's different from the main claim period.
Okay.
And my learned friend actually didn't press the point when it came to it in the Upper Tribunal 2023. But my learned friend can have a go with Section 80 on the basis of Iveco, but chose not to. I can say it's swept up into the old scheme. But on this this strikeout, I say, well, where's your mistaken unjust enrichment claim? Because all you did was fail to claim.
Okay.
And I don't think I can put it further than that. And the secondary sort of point.
So
I
you
make-
accept that at least one of your arguments on issue 2 doesn't follow through into the 9-month period?
Yes. Yes. No, the 9-month period is different because it doesn't have the old scheme. So I can't say for the I don't say on the strikeout for the 9-month period. The taxable amount is reduced subject to the conditions of the member state under 11C1, and here are the conditions of the member state. It's the old scheme. If you didn't, it was nicely summarised earlier, if you didn't use the old scheme, then the tax paid was the tax due. I can't say that for the 9-month claim. But however my learned friend formulates his claim for that 9-month period, it's not going to be under the old scheme, but however he formulates it, how is he going to show that it's a mistake-based claim? So yes, the two are, strikeout, the two are very different. And we also take the point in the 9-month claim that my learned friend won't be able to satisfy section 32(1)(c) as in when was there reasonable knowledge of the mistake, because it may be won't be difficult, but it's more difficult to show it in relation to the main claim period, but it's because you've got the insolvency condition, and when would you have known that the insolvency condition was problematic, and so on. There are some complications. But in the 9-month period, all that happened is that HMRC hadn't implemented Article 11C1 at all. It had done nothing.
Well, it must be a question of fact as to when that was reasonably discoverable, isn't it?
Yes, and so, unless it's so obvious from this is how I put it. It's so clear that that BT would have known that I included in my strikeout argument. So 32(1)(c).
Well, should have known. You rely on the
Yes,
discoverable.
could have been corrected. Could have known. And I say could have known. In particular, I think the big case I rely on for that is Goldsmith. Goldsmith was the trader who complained about the barter, the limitation, the condition in the original old scheme claim that it only applied to consideration in money and didn't apply to barter transactions. Goldsmith complained about that to the Manchester VAT Tribunal in 1994. And it was sent up to the CJEU in 1997. And the CJEU said derogations had to be justified. So, although we know that there's this second sentence of 11C1, in the cases of total or partial non-payment, member states can derogate. It was made clear in 97 by the CJEU in Goldsmiths that derogations had to be justified. And we say that that would have been sufficient knowledge to show BT that it had the potential of a worthwhile claim, enough to start embarking on investigations and so on. BT hasn't, I think, ever explained to us what happened in 2010 when it brought its claim that gave it this valuable knowledge, or why whatever it was, something they didn't know before 2004. It's not pleaded that an answer to that point. 2004 being important because it's 6 years from the date of reasonable knowledge. But I don't think I can say much more than that on the 9-month claim. So that's all on the issue 3, unless I can help further. And I stuck by the original timetable, so I hope we're on track.
Thank you very much indeed. Yes, Mr. Cordaro.
Very great. So I'll make a start on this 2.
Yes.
my friend has understandably placed a lot of reliance on the position as to tax due or not due in the BT Court of Appeal decision. And obviously you're well aware that we say what we say based on Deutsche, Morgan Grenfell, and the potentially limited impact of the approach to essentially having a freeze frame of analysis in terms of various moments in time and the state of account between the taxpayer and the Treasury. We say you have to run the film and look at it through time, T1, T2, T4, rather than take a limited shot in time, which ipso facto writes out of the story beliefs and unexercised rights. I've called for a case which we'll have in the morning, won't be controversial, FDR, in which, or Justice Law's that case, held that exercising a set-off is a payment for VAT purposes. And on the basis of that, we will say that an unexercised set-off is also a transfer of value in the sense that you have not exercised the set-off, and therefore you've settled gross, you've transferred gross value where you could have transferred net. So that'll be a short point, I'll make that briefly in the morning. But the unexercised right is, as you will readily appreciate, fundamental to the way we asked you to look at the economic interaction between the parties under the mistake doctrine. The second threshold point I make is this is a mistake. It has a long history. The law of restitution has been identified from the disparate 300-year history of inter alia, the equitable jurisdiction in a mistake. But at the end of the day, the equitable jurisdiction is for relief against the consequences of a mistake. We say they fit perfectly into the current dialogue as to transfers of value and failure of basis. But if for any reason it doesn't quite fit, it should not be a basis for defeating the claim. If the court is satisfied that one party is richer than it would have been had the mistake not been made, and that it's not just that such it be, and that's the ultimate touchstone test, naturally, that we urge upon the court. So those are two threshold points. My learned friend endeavours to create a no-go zone for me in my submissions on this point by reference to BTCA. And obviously she's entitled to make that attempt, but as we have already perhaps identified, the Court of Appeal only had a statutory jurisdiction, wasn't ruling, or perhaps a brief comment thinking about a common law restitutionary analysis, and therefore we say the Crown is pushing it too hard to say that anything that is said in BTCA precludes our continuing our claim under this issue number 2. In a nutshell, what we say happened in BTCA is that we proposed that we had a Section 80 domestic law claim. You've seen the entirety of the reasoning, by the way. It was paragraph 30, Dr. Lassock's argument, and paragraph 127. And that's it. There's nothing else. And the only express references in the judgment, the only express quotations in the judgment of Section 24, Section 80 are of Section 24. The court was well aware that it had been replaced, of course, but the only text that appeared in the judgment is the text at paragraph 29 of the judgment, page 1100 of the bundle. But the text is there. The text doesn't include the later amended version of section 80, and that may or may not be relevant, but I just want to keep things very, very straightforward. So against the background of that text, see para 29, and the argument, see para 30, Lord Justice Reimer and the rest of the court took a very simple temporal sequential view, and I'm turning to and invite you perhaps to look at paragraph 127. I've been saying 127, I should be saying 125, I beg your pardon. The point that is there taken is that since the money was undoubtedly due when paid, and certainly since the wording of section 24.1 says where a person has paid an amount to the commissioners by way of that which was not due, was not tax due to them, they shall be liable to repay the amount to them. The factual situation in BT didn't fit the domestic statute. So the sequence there was payment tax due, see Article 10 of the Sixth Directive. We haven't shown them to you, but there are perfectly proper UK implementing regulations for that. Look at section 24.1, or at the very least the early version of section 80, and there is no more to be said. The difficulty about that it binds, is that Article 11C1 doesn't take any position on the sequence of the various events, the cancellation, the bad debts, and so forth. We can readily imagine that the time when you need Article 11C1 the most is when you are seeking to recover tax from the Treasury. Because if the event happens before you've paid, you don't pay it. If within the course of one prescribed accounting period, 3 months, you do a job and then the client says, won't be paying or can't pay, or let's agree to a rebate of 50%, then you do that and you fill in your accounting documentation or VAT return on that basis, and you've behaved lawfully, but you don't need to reclaim anything. Naturally, if the commissioners audit you and they see that, you can refer to 11C. But most of the time, 11C is needed when you have paid and you're seeking to recover. Be that as it may, this court decided that Section 80, notwithstanding that it was the go-to provision for San Giorgio restitution, would not apply in any situation where the tax had been due when originally paid. That's the decision. That was not a decision based on the existence of or ousted by the bad debt regulations. It was a decision based entirely on temporal sequence, and therefore prima facie was of equal application to all 5 gateways. So if, as Iveco did, you had sold your fleets of vehicles, accounted for that on the selling price, and then at the end of the year totted up how many vans the post office, for example, had bought and gave them a rebate, you would not be covered by Section 80 because the sequence was wrong, and Iveco would have, the Iveco character in the story, would have paid the VAT when due, and that wouldn't pass the test in paragraph 125. The explanation, therefore, of why in Iveco there wasn't a simple defence to Iveco's claim, well, you're not covered by Section 80, is that in tactical terms, the interests of the commissioners, and there's nothing improper in any of this, were completely different BT, the commissioners needed to prevent BT from getting into the Section 80 machinery because they were in time. BT, subject to the letter point, BT made its claim, good or ill, within the window. Iveco, on the other hand, missed the window by miles and only came to the party much, much later. And therefore, from the Commissioner's point of view, it was in their interest to draw Iveco into Section 80 and then rely successfully, as they did, on the time bar. That is one oddity, which is just there, it just sits there. In Iveco, in paragraph 1, it indicates that the rebates were given later and so forth. But the way that the argument proceeded in Iveco was completely different. And I say all that because in Iveco, there is a thorough, if I may say so with great respect, examination by this court of the workings of 11C. And Lord Justice Nugee goes through it, dip into that as far as needs be. But it operates on a European plane. Iveco operates on the basis of how Article 11C works. BT operates on a purely domestic plane. You've seen the entirety of this. And it's the simple point that the domestic procedure simply doesn't cover these facts. Nothing was said in BT to the effect that on the facts, Article 11C wouldn't have applied. Quite the contrary. The first two-thirds of the decision confirm that notwithstanding that BT paid the money when due in Section 80 terms, its 11C rights were activated. And that, in my submission, is the point of entry for the analysis, because we say that BT clearly activated their rights under 11C, notwithstanding the failure to claim. And we rely on Iveco in its analysis of how 11C works automatically to underpin our claim that even if we didn't have a Section 80 claim because of the shortcomings of Section 80, on any view, the events interacted directly with Article 11C and Article 11C would have been triggered. The decision for this court is, does it matter? Because the critical point is that no claim was made, and we say ultimately it doesn't matter. The question for you is simply about the failure to make the claim, since the Crown would apparently accept that if the claim had been made, whichever view, in whichever case is quite the governing view, that there would have been a crystallised liability. But insofar as it does matter, then it is right that when this court disposes of the case, it does so on a basis which reflects the underlying European position. So if I could just invite the court with that rather lengthy prologue, just to look at the decision in Iveco. And if I may, I will, conscious, we only have a few more minutes, but it's perhaps worth my just beginning so that the court has a sense of where we're going with this. So the decisions in the bundle, as you know, at page 1437, I can't remember the divider.
54.
Grateful. Thank you. And so the position at paragraph 1 indicates that just below letter F, and there's more on this in the decisions below if there's any according to, I'm looking at page 1440, according to either code, a rebate served to reduce the price of the relevant vehicle, but it did not make any VAT adjustment in respect of them. On that basis, it claims to be entitled to the repayment of 73.3. So that's why I say, as one would expect, if these are rebates for volume purchases, one would have charged and paid the VAT in full, and later got round to making a claim, in Iberco's case, not for many years. So what the peculiarities I've identified is why the claim wasn't resisted purely on that ground. It wasn't. And then if one turns to the analysis of Lord Justice Nugee, and he deals with BT at page 1449 and paragraph 35. He doesn't. I don't think he quotes paragraph 125. I may be wrong. I don't recall his quoting paragraph 125. But it's at this stage of the analysis that his lordship comes to the crux. Perhaps if you'd kindly start at 33. Mr. Hitchmo, for the taxpayer, argued that the upper tribunal recognised in this passage that GMAC could not be said to have accounted to HMRC for more VAT than was properly due unless and until the claim was made. Moreover, so Mr. Hitchmo said, the Court of Appeal has subsequently endorsed that view, as to which see paragraph 38 below. I pause, as is so often the case, everyone's changed seats, and the taxpayer is arguing that no claim became due until made, and the commissioners were arguing the opposite. 34, Ms. Mistrofanous, however, disputed Mr. Hitchmo's interpretation, paragraph 4 of the upper tribunal's decision. She attributed the perceived need to claim appropriate relief to the fact that the upper tribunal was dealing with bad debt relief, which has always depended on the creditor asking for it. And then, in this connection, she refers to Section 12 of the Finance Act, 1978, which provided for a person to be entitled to a refund on the making of the claim to the Commissioners, Section 22, etc. I won't read those. But just taking it up 5 lines down, she pointed out too that the upper tribunal could not have been proceeding on the basis that GMAC would have been able to trigger a reduction in taxable amount at a time of its choosing, since the tribunal could not then have concluded, as it did, that BT's similar claims would be time barred if they fell to be dealt with under Section 80. Had it been the case, Ms. Mistrofanous said, that no taxable amount was reduced until the taxable person claimed, there could have been no question of BT's claim being too late. In all the circumstances, it seems to me that the upper tribunal's decision can't of itself lend any support to Iberco's case. I just pause for one moment. His Lordship quoted and asked the court just to keep a finger for 60 more seconds in the bundle at 1449 and just go back to 1443. I should have done that before. Lord Justice Nugee quotes Section 80 as it relevantly is today, and indeed relevantly was during BTCA, and just by letter G is the provision: the commissioners shall only be liable to credit or repay an amount under this section on a claim being made for purpose. So, in just about perhaps to draw stumps on the point, what we'll see tomorrow morning is how it was, notwithstanding Section 80, sum 2, notwithstanding the lack of any claim by Iberco for many, many years, nonetheless, Article 11C activated Section 80. And the point I seek to derive from this is Article 11C wasn't neutered in performing at least its function, directly effective function, by the presence of domestic requirements to make a claim, be they in Section 12 or Section 22 for bad debt, or Section 80 sub 2 for restitution. That is a purely domestic defence, but Article 11C, for the reasons which we will see in the morning, Lord Justice Nugee sets out very clearly, operates willy-nilly. I propose to pause there. I have available the pleadings my Lord inquired as to the pleadings in the BT tribunal litigation. Shall we hand them to your clerks for perusal if you wish? And by the pleadings I mean the notice of appeal and the statement of case, which is defence.
Well, if you think they're relevant, I think Ms. Trofford thought they weren't in the end of any relevance.
They have a 3-minute relevance. Put it that way. But I can deal with it in the morning.
Let's deal with it in the morning.
Including our evening.
Yes. Very well. 2 o'clock. 10:30.
Court rise if able.
Could I trouble you for the pleadings tonight rather than tomorrow?
Absolutely, yeah, they come
I
into
vaguely remember
Right.
actually writing
I have
something.
no memory of
And yet you know that they have 3 minutes relevance. You've
where
got
did that come from?
2 documents each. Sorry,
Oh, I see.
no
They just.
statement of
Oh,
case.
oh, right.
Times 2.
Okay. Yes. So there's notice of appeal.
Yeah. Statement of case. Do you want to give one to me?
I can forfeit my hard copy if you
No,
want.
no, don't worry. That's fine. Do you need to see?
How are we doing for
Well, I
time,
don't know
Margaret?
why would I need to see it?
Any,
What's it
you
on?
don't know. I mean, I'm not
Do you know
holding you
what
to
point?
something. It's
No,
just
I
You
mean,
know.
you'll think about it overnight.
well, have I got 2 hours?
I better give them to you.
Yeah, I suppose.
What do you
10:30,
expect?
11:30, 12:30. Sorry, I'm too tired to even think.
How much time do you want?
I don't know what you're going to say, Roderick. Are you going to go through all your points in your skeleton? In
I'm
which
not
case
sure. No, I'm not sure. I'm going to go for the big points. The big killer points.
you don't want to tell me which ones you regard as the big points. do
I,
you?
I,
You're going to make me go back over the.
no, I'm not holding anything back. Big.
That's just mean.
No, honestly, I'm very dehydrated. That is the problem. And if we'd had the breaks, one could keep drinking.
Roderick, you got water?
Okay, I will pack and then we'll reassemble. Yeah, I can be able to look at the green.
Okay. Because I've gone through steps they've moved it, which is actually once we go back to the it's really clear.
Yeah, that doesn't matter.
There's the recordings. Yeah, we've got some points, but they're all
No.
There's not been
No,
much
it's a
If there was another one,
So I also have
yeah.
and therefore it's only